welcome to our video, How to Divorce Without Conflict. I'm Alexandra Getze, and I'll be presenting the information to you today. So first, thank you for joining us and watching the webinar. If you're looking for information about how to divorce in Texas without conflict, you're in the right place. Now, you may be thinking, is divorce without conflict even possible? And I'm here to tell you, yes, it is possible. By the end of the webinar today, and by the end of the video today, you'll understand the Texas divorce process. You will understand a few of the collaborative ways that you can get divorced, and you'll have an introduction to divorce planning. Using this information, you'll be able to make informed decisions about your divorce that will help you minimize the conflict of divorce. Now, full disclosure, here's the legal lawyering part. Today's video is not confidential and we are not your attorneys. The information that we're presenting today is not legal advice. It is general, broad, and informational only. We urge you to speak with an experienced attorney about your particular situation before relying on any of the information in this presentation. Depending on your circumstances, the information may not be accurate to your situation. So if you have any questions about what I'm presenting today, please feel free to send us an email through our contact page on www.familylaw.com. So first, a quick introduction before we dive into the materials. I'm Alexandra Getze, an attorney, mediator, collaborative lawyer, and founder of Alexandra Getze Family Law. I'm also a wife and mother of two. I've been practicing family law for over a decade, and I've helped hundreds of clients reach amicable settlements and move on to better, brighter futures. I've been recognized as a Texas super lawyer for many years. I'm a member of several organizations that recognize achievement and professionalism in our field. I've been published in a variety of online and hard copy publications, and I've spoken at conferences and events throughout the state of Texas. Our firm has countless reviews and testimonials from happy clients on our website and also on other sites like Yelp, Avo, Google, and Facebook. And if you check them out, you'll see that we really do practice what we preach. We care about our clients. Now, a few years ago, I decided to dedicate my practice to representing women and focus on women who are searching for a better way to divorce. Women who want the freedom to live a more fulfilling life without blowing up the life that they're trying to let go of. We use a collaborative approach to divorce that focuses on planning and strategy as a way to minimize the conflict. While most divorces do have some level of conflict, if you're looking to blow things up and want a pound of flesh, or you're married to an extremely narcissistic husband or spouse who is going to be blowing things up, then we may not be a good fit for you. While we have experience with those things, that's no longer the focus of the firm. However, the information that we're going to be presenting to you today can still be helpful for that situation. Now, let's dive into the material that you came here to learn. First, we're going to talk about the Texas divorce process. Then we'll cover some of the different approaches to divorce in Texas. And lastly, we'll introduce you to divorce planning and how you can minimize conflict. So, what is the Texas divorce process like? Divorce law and processes can vary from state to state. In Texas, the legal process of divorce itself is fairly straightforward. So long as the parties are able to reach agreements, then there is no need for trial or extensive legal battles. The basic 10,000-foot overview of divorce goes kind of like this. First, you're going to draft documents and file them with the clerk's office in your jurisdiction. Upon filing, you're going to get assigned a specific judge and court that you're going to be working in. Now, there is a 60-day cooling off period for most situations, and that just simply means that you and your spouse cannot get divorced prior to 60 days after filing, just in case you guys change your minds and want to reconcile. It does not mean that you'll necessarily be divorced in 60 days. In fact, most divorces will take a little bit longer than that. The next step is to notify your spouse that you have filed something. So we have to give them notice. Even if your spouse and you are in total agreement and your spouse knows that you filed for the divorce, the court still has to have some sort of proof that they know about it. There's several ways that you can notify your spouse, but the two most common ways are to either serve your spouse with papers by a constable or private process server, or to have your spouse sign a waiver of service. And there are pros and cons to both methods, and let's talk about those. Process service can be done quickly, discreetly, and it does not require your spouse to actively participate in anything. Your spouse simply receives the paperwork, and then the process server or the constable goes and files the information with the court. A waiver of service can also be done quickly and more cheaply. However, your spouse will need to sign the waiver in front of a notary and then either file the waiver himself or send it back to you or your attorney to get it filed. It does require cooperation. So if your spouse will procrastinate or take advantage of the extra time, then a waiver of service may not be the best method for you. Regardless, both methods can be done amicably and without blowing things up. Now, once your spouse has been legally notified, he's going to have about 20 days to respond. Most spouses at that point will hire an attorney, or they may tell you that they're going to represent themselves. When a person represents themselves, it's called pro se. A pro se party is presumed to know the law as well as an attorney, and your attorney cannot give him legal advice. Now, it is possible for one attorney to draft up the paperwork for both of you and to negotiate terms with your spouse. But if your spouse has legal advice sorts of questions, the attorney cannot answer them. And in Texas, a lawyer cannot represent both parties to a divorce. They can only represent one party. Now, at this point, you and your spouse may need to establish some ground rules. Since there is a waiting period and it will take some time to figure out how to separate and transition everything before the final settlement is reached, you and your husband may need to have some agreements in place about who gets to live in the house, who pays the bills, how visitation and child support will go, and things like that. So at this point, you may not be ready to start negotiating and reaching final decisions about how the assets and debts are going to be split, or what even the final custody arrangements are going to be. You may want to experiment a little bit. So these ground rules that you establish are called temporary orders. And they can be verbal agreements, they can be written agreements, or you may have to go to court and have the judge establish what those ground rules are going to be. In most situations where parties are in agreement about things, though, we don't generally need temporary orders. So gathering information is the next phase of the divorce process. At a minimum, you should have a marital disclosure of all the assets and debts. We call this marital disclosure an inventory and appraisement. If you have no assets or debts, then you may not need one of these disclosures. But even if you and your husband are in agreement about how to split things up, you may still want to get this legal disclosure to help the attorney draft the paperwork and to guide you in the details about how to divide things up. For example, you may want to split things 50-50, but you may not know what is the best place to pull those percentages from. For those who need a little bit more information than just the marital disclosure, lawyers have a variety of tools and resources at their disposal called discovery. Discovery is the process of discovering information about the case. Discovery can include formal questions that they serve on the other party, and those have to be answered within a certain amount of time. It can involve subpoenas, depositions, and other things like that. Not all cases require discovery, and it is not required for you to get divorced in Texas. So that's the good news. Now, once you have the information that you need to make informed decisions about your divorce, the next step is to engage in negotiations. Negotiating before you have the full picture can be tricky. Let me say that again. Negotiating before you have the full picture can be a little tricky. We get lots of inquiries from clients about wanting to mediate before they've even filed for divorce. This is usually not a good idea because you may leave out lots of details, or you can walk away from property that you may be entitled to, or lose your custody rights, or other things like that. Negotiations really don't have to be complicated. You can reach agreements informally with your spouse, or the attorneys can talk and hash it out, or you can go to mediation, and we'll talk about mediation in the next section of the video. The good news is that most divorce cases will settle through negotiations. Even cases where you think you and your spouse can't see eye to eye at first, it is likely that you're going to reach an agreement at some point during the divorce process and settle things. However, if you don't settle, then you're going to have to prepare yourself to go to trial and go to trial. Family law trials in Texas can be heard by just a judge, and those are called bench trials, or they can be heard by a judge and jury, and those are called jury trials. Regardless of how you do it and go about it, the result will be that you're going to have a decision in your case, either by agreement or by a decision of a third party like a judge or jury. So the last step in the process is to present that final decision or final agreement in a formal legal document to the court called a final decree of divorce. Normally, you present these final documents to the court in a hearing called a prove-up. It is a quick hearing. Only one of you has to attend, just so that you can formally present the documents to the judge and put on testimony on the record about your names, counties of residence, and things like that. However, with COVID, many of the courts now are accepting these documents by online submission and a sworn affidavit in lieu of a court appearance and testimony. The court normally approves the final document, at which point you will be divorced. Now, in Texas, you cannot get remarried without the court's permission for an additional 30 days after the document is signed, but you're free to get married all you want after that. All right, so that is the Texas divorce process in a nutshell. There are a number of other things that can draw out a case or create more litigation, but for most agreed divorces, that's about how things are going to go. Next, what are some of the different ways that you can get divorced in Texas? In Texas, most divorces will move through courts by litigation. However, in some cases, we do use collaborative law, and you may have also heard of terms like mediation and uncontested and wondered if you should represent yourself or hire an attorney. So let's look at these different options and clarify. Litigation. Litigation does not necessarily equate to conflict. Let me say that again. Litigation does not mean conflict. Litigation is the process of taking legal action and the rules that we use to move a case through the legal system and the court system. Whether or not a case is high conflict or in total agreement is irrelevant. The amount of litigation that happens in your case will depend on the amount of conflict. In the best case scenario, you and your spouse will agree on everything and the judge will simply sign off on the final papers. In the worst case scenario, you will end up in trial and the judge or jury will decide the terms of your marriage dissolution. The good news is that most family law cases will settle at some point during the litigation process. Collaborative law. In contrast, collaborative law is a legal process that enables couples to work with a team of collaboratively trained professionals outside of the court system to achieve a settlement that meets their specific needs. It is a voluntary process that begins by filing paperwork with the court, but then suspending the litigation process to give the parties time to work out the details of their agreement. The parties sign a written contract, an agreement that they will freely exchange information and communicate openly to reach a mutually beneficial resolution. Now, even though there is an open exchange of information, each party still has confidentiality with his or her own attorney. The parties work with their attorneys as well as a financial professional and a mental health professional in most, but not all cases, and they meet for a series of several sessions over a period of time, kind of like mini mediations. The collaborative law process can be used for divorces as well as for negotiating premarital agreements, postnups, and cohabitation agreements. Once the parties have reached an agreement through collaborative law in their divorce, the paperwork will be drawn up and presented to the judge for his or her final approval and signature. However, in the event that the parties are not able to reach an agreement in collaborative law, then the collaborative professionals are going to be let go and fired, and the parties will each have to hire new attorneys to represent them in any subsequent litigation. Collaborative law can be a great option for some, but it's not for everyone. And not all cases where the parties want to collaborate and be agreeable have to go through collaborative law. So talk to a collaborative trained professional to learn more about what's best for you. Mediation. How is mediation different from collaborative law? First, mediation is part of the litigation process. In most cases, you don't mediate until you have gathered and exchanged information that will help you in negotiating your position. Second, mediation is generally more adversarial than collaborative law. There's no open communication, and you do not work with a team. It is you and your lawyer in one room, your spouse and his lawyer in another room, and a mediator that bounces back and forth between the two rooms to try to facilitate communication and work out some sort of deal. Mediations are usually done all in one day, whereas collaborative law is done over a series of meetings over a period of time with different professionals. For example, in collaborative law, you may have one session focused on co-parenting, where it's you and your spouse meeting with the mental health or a parenting professional, and then another meeting where the two of you are meeting with the financial professional and the lawyers aren't involved in either process or either meeting. Mediation may be required by some courts before you can set a trial date, but collaborative law, like I said earlier, is a voluntary process and is not required by the courts. If you'd like to learn more about collaborative law or mediation, please visit our website at www.familylaw.com/collaborative law or /mediation. Personally, I am an experienced litigator who's also a certified mediator and a trained collaborative law professional. So if you give us a call and contact us, we are happy to explore which option is best for you. Lastly, let's talk about divorce planning. I love divorce planning, and it's one of the things that sets us apart from other firms. So what exactly is divorce planning, and how can you use it to minimize the potential conflict? Most divorce lawyers don't give divorce planning much thought. They simply accept a new client when that comes in the door, and then they go and file the divorce case. But as my practice evolved over the years, I discovered in cases where we do divorce planning, the parties were actually able to reach agreements faster. They were able to preserve their relationships better and transition more smoothly. So if you're thinking about divorce, speaking with an attorney sooner rather than later is really best. The situation is not going to get better. Keep in mind that the longer you wait, the longer it's going to take for you to start that next chapter of your life. The longer that your children are going to continue to observe a dysfunctional marriage. And if something happens to you or your spouse, you may end up on the hook for bad acts, or you may end up receiving less property than if you'd filed sooner. Another way to put it is, if you won the lotto, then your spouse would be entitled to a chunk of that money. So go ahead and talk to an attorney and get the planning process started. Just because you speak with an attorney does not mean that you have to file for the divorce right away or even at all. Divorce planning is a practical step in the thought process that will help you feel more confident about whatever decision you make. Divorce planning involves goal setting and answering many of the questions that you may have swirling around in your head when you first start to think about divorce. Things like, what are my rights? How much money am I going to need to live? Who will live in the house? How will we split up the house? Do we have to split up the house? Do I need to get a job? How will we tell the kids? What information will I need to pull together? What steps am I going to have to take to protect myself and my family? Divorce planning can answer all of these questions. Divorce planning minimizes the destructiveness and the destruction of divorce by educating you about your rights and your options. I learned that much of the destructiveness that I saw caused by divorce stems from the misunderstandings and fear. So when you plan things out, communication improves, your goals slide into place, and the fear just dissipates. So while most firms dismiss divorce planning, we actually focus on it. Almost all of our clients begin with us through a divorce planning strategy session before we even file. Prior to the session, we send the client information to prepare, and then the client will speak to an attorney about her particular situation. At the end of the session, the client has a plan of action and concrete next steps. If you'd like to learn more about the divorce planning process and our strategy sessions, please visit our website at www.familylawdfw.com/divorce planning. As you can see, there is a variety of ways for you to minimize the conflict of divorce. If you'd like to explore what options are best for you, then please reach out to us. We do offer a quick complimentary case evaluation, and if you want to move forward with a consultation, then we charge a nominal fee. However, if you call within the next 30 days of watching this webinar and mention the code word webinar, then you're going to get 50% off the consultation fee. There's absolutely nothing to lose by scheduling a consultation. If you retain us, then the fee is going to be applied 100% towards your retainer. And if you don't retain us, well, then you've walked away with knowledge and peace of mind. And remember, just because you have a consultation does not mean that you have to retain us or even file for the divorce. Our consultations are an opportunity for us to meet each other, for us to understand your situation, and to see if we're going to be a good fit for one another. Most people that we consult with walk out of the consultation telling us how much more confident and at ease that they feel. So I hope this webinar and this video was helpful to you today. Our website is chock full of resources, but in addition to that, we have a YouTube channel and a Facebook page that has lots of other information. So please go and check those out as well. And remember, divorce doesn't have to ruin you. Divorce can set you free. Take care.